The concept of direct versus consequential damages comes up in all sorts of commercial contexts, and so that's what we're going to be talking about now. If we go back to Hadley and Baxendale, the basic concept is there are two categories of damages, as the court in Hadley indicated, where two parties have made a contract, which one of them is broken. The damages should be either one, such as may fairly and reasonably be considered either arising naturally, i.e. according to the usual course of things, from such breach itself, or two, which is what we're going to talk about in a second. Category one here are what we call direct damages, or damages that naturally flow from a contract breach. And the concept is that these are the kinds of damages that anybody ought to foresee as being the natural consequence of a breach. So, for example, if I have a contract with you where I'm going to build a house for X number of dollars and I breach, so you terminate the contract and have to find a replacement contractor, and it costs you X plus Y in order to finish the work and get the house, then that extra amount, that Y, is what I'm going to be liable for, because that's pretty much what you would expect. Right? Those directly and naturally flow from my breach. Same thing if I am supposed to be selling you widgets, and we've agreed on $5 a widget, I breach, and so you have to go buy widgets at $6.50 a widget. Okay, I'm going to be liable for the $1.50 difference. And so those are damages that anyone should be able to foresee simply as a result of the breach. So the category two damages are essentially consequential damages, or in Hadley and Baxendale terms, such damages as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of a breach. So, for example, if you're supposed to be building me a hotel and you're late, I may not have any direct damages in the sense of damages that represent additional costs of completion because I had to hire somebody else. It's simply that you're late. But I was planning to rent the hotel out to paying guests over the holidays, and so I've lost revenue on those guests who aren't staying because the completion of the hotel was delayed. Well, lost profits on third-party contracts are a classic example of consequential type damages, right? It's not something that is necessarily in your contemplation, right? You don't necessarily know. It's not necessarily foreseeable to you that if you're delayed in completing the hotel in a week, that I'm going to lose revenue. For all you know, the hotel would not have had any guests in that week that you're delayed in completing the construction. Or in my widget example, if I'm supposed to be selling you widgets because you plan to put flanges on them and resell them at a profit to and have contracts in place for selling them to Walmart, for example, and you're going to make lots of money on the resale to Walmart. If I don't know that what you're going to do with the widgets I'm selling you, I'm just selling you widgets and maybe they're for your widget collection or something. I don't know what you plan on doing with them. I don't know about the contract with Walmart. It's not foreseeable to me that you're going to lose profits on the Walmart contract if I breach my obligation to sell you widgets. And so consequential damages, the classic example of consequential damages are lost profits on second contracts that the innocent party entered into or was going to enter into that the innocent party can't enter into or can't perform as a result of the breach of the original contract. And so in order to recover those kinds of consequential damages, in Hadley and Baxendale terms, you have to be able to show, the innocent party would have to show, hey, I told the breaching party look, I've got this contract with Walmart, so I really need the widgets. Or I told the contractor, look, I've got bookings for the week between Christmas and New Year's, and I'm going to have to cancel all those and lose all that revenue if you aren't finished with the hotel in time. That's what it means by saying that the damages are such as may reasonably be supposed to have been in the contemplation of both parties. If the innocent party, the injured party, has expressly told the breaching party at the time of contracting, look, I need you to perform this contract so that I can perform my other contracts, that would be actual knowledge by the breaching party of the circumstances that would permit recovery of consequential damages. But there doesn't have to be express notice in that way. It could be that the surrounding circumstances lend themselves to a reasonable inference that the breaching party should have known constructive knowledge of the consequences of a breach. So it's important to keep these two categories distinct in your mind. Now, the line between direct damages and consequential damages is not easy to draw. The distinction is easier to state than it is to apply. Nevertheless, it's important to understand that there is a distinction, especially when you see contracts that have waivers of consequential damages in them, where both parties agree they aren't going to claim consequential damages against either one, which commercial contracts very commonly do, almost invariably have waivers of consequential damages. And so the question becomes, well, what exactly has been waived here? We understand in general terms what consequential damages are, but in any specific case, does a particular item of damage really fall within the definition of consequential, or is it really more direct? And that can become a very thorny problem to sort out. Now, that same concept crops up in the restatement, the same distinction between direct and consequential damages, particularly in section 351 of the restatement. And the going-in position, not surprisingly, is that damages aren't recoverable unless the party in breach had reason to foresee that those would be the damages that would result if there was a breach. Okay, so the same concept of foreseeability. Now, that gets a little more definition in the next section. Subsection 2 says, okay, it can be foreseeable either because A, these are the types of damages that arise in the ordinary course of events, i.e. Hadley Category 1 damages, or B, as a result of special circumstances that the party in breach had reason to know, i.e. Hadley Category 2 damages. So you get the same two categories that we saw in Hadley and Baxendale replicated, not verbatim, but close to it in section 351(2) of the restatement. So the distinction between direct and consequential damages is really fundamental in commercial contracts, and something that you have to start getting comfortable with, even though the theoretical distinction, while it's clear enough in the abstract, can be very difficult to apply in practice.